Models and damages. You know, somebody already referred to it this morning on the panel before this one. There's an 800-pound whatever in the room when you talk about damages and models. And the question is, if you're going to try a case and you're a defendant, are you going to put up a number? Are you going to do a calculation of damages? Are you going to do a model that calculates damages? I tried cases for years that were products, malpractice, cases like that, death cases. And those are models too, right? I mean, you kill me, and so what's the model of what the rest of my life was going to be like if you hadn't killed me? I mean, that's where you are. And it's the same in every one of these cases. Was I going to become Albert Schweitzer or a convicted felon? Or somewhere in between for most of us, hopefully. So I never put an expert on the stand to testify in those cases about damages. Never. I used cross-examination, and I used a consulting expert to help me. But I never put somebody on the stand who effectively was going to validate the plaintiff's expert's methodology. You validate the methodology, you set a floor, as somebody said earlier this morning, and you confuse jurors tremendously about whether or not you're arguing that you were at fault. I'm sure Ron remembers this. We did a mock. We did 4 mocks for this case that we tried. And one of the jurors, one of the mock jurors, concluded in the liability part of the case that the defendants did not infringe the patent. Then that juror was confronted with a damages question about what's the reasonable royalty or should it be lost profits, the damages. And his reaction was, I mean, it was mind-blowing. He said, if those guys are willing to pay reasonable royalty, because that's what they're arguing for, because the court wouldn't bifurcate damages and liability. That happens all the time in the United States of America. You know, and if I were a judge, I wouldn't be bifurcating much either. You know, I'd just say, bring all your protective gear and try the case. So what happens, you know, when you do that is, this guy said, they're willing to pay reasonable royalty. They must have done something wrong here that we just can't understand because this is a technical case. And I'm going to change my vote on liability. That's the problem you have. People don't understand. You know, intellectually, I can say to you, hey, the fact that we're talking about, this is what the charge sounds like. I don't mean to be disrespectful to anybody, the judiciary in the room. It's, you know, just because we're talking about damages doesn't mean that there's an entitlement to damages here. Doesn't mean that. But people don't get it. They don't understand. They can't hold in their mind the two separate concepts that whether you're at fault or whether you have liability is different from what that is. They don't let you argue both. If you try to choose both of your poisons, you can really get into difficulty. Now, some cases are different. We're going to talk about that right now, but it's very different. Comments from you guys about this? I mean, you guys are in the sort of the business where this is important.
I mean, again, I think it's a reputational risk. I mean, you have to kind of prepare the stuff and anticipate how someone else can break down your model. I mean, if it gets, you know, obviously, you know, you're going to, no matter what you put out there, you're going to have on the plaintiff's side, someone else is just going to tear it apart and kind of put, you know, punch holes in your model. So I think you have to be prepared in order to, you know, kind of fight that, you know, combat that.
Yeah, I mean, from my perspective, it's always a frustrating thing to see. You know, from a defense perspective, putting a competing damages model it in many instances wipes away your whole liability case, as you're saying. I mean, I would like to hear from, you know, many people in this room, you know, and people who are in-house. How do you, I mean, it's a risky proposition, right? I mean, you know, not putting on a, you know, competing defense damages analysis because you're putting all your eggs in the liability basket. If you lose on liability, well, they've only given us one other number, which is the plaintiff's number to deal with. So, I mean, I think we could have a discussion, a long discussion on, you know, what the best way to present a competing model might be, and when, in what instances, don't you put on a competing model?
I often would say to juries in cases, death cases, ugly, ugly, ugly products liability death cases, the revenge of the Industrial Revolution. You know, I said to juries, if you're waiting for me to stand here, ladies and gentlemen, and tell you that a human life doesn't have any value, or that the plaintiff's life doesn't have any value, you're going to have a long wait, because I'm not going to tell you that. That's not why I'm here. And then I go on to talk about liability. And it's a way of sort of, you know, not dealing with the question when the guy says he wants $5 million or 15 or 50 because some man or woman was eviscerated by a product. And, you know, and you have to deal with that.
I was just going to say, you know, in a PI case, I agree. You know, extraordinarily dangerous cost-benefit analysis does not fall in your favor for putting on a model. In a commercial case, then it could make sense. Then it could make sense because, you know, for all the reasons you've said.